Today or tonight I rise to speak on the Corrections Amendment Bill 2026. We will not be opposing this bill, but I am going to point out what is missing from this bill and what is, quite frankly, not in line with community expectations. So the background of this bill is this, that recently an underworld boss, George Morogi, I've got his name right. George Morogi recently won a legal battle regarding prison conditions. So this man is serving a 38-year sentence for murder and for drug trafficking, and he took the Victorian Department of Justice to the Supreme Court and won. And what this was over, he argued that his rights had been breached. The essential reason is because the courtyard in his prison cell, because he was in a high security prison cell, the courtyard out the back was too small, restricting his open air access. And he claimed, and it was proven by the courts, that this happened in the Melbourne Remand Centre and in Barwon Prison. And the judge said this: the yard felt enclosed with limited room to move around, and the only view to the outdoors, being the sky above the yard, was through a roof, through the mesh on the cell roof. So as a result, we are dealing with this Corrections Amendment Bill today. And in doing so, we're amending the piece of legislation that addresses prisoners' rights within corrections settings. This is the very piece of legislation that thousands of Victorians have petitioned to see changed. Yet the government has gone nowhere near the changes that the community have asked for. In less than 2 years, I've raised the need to change this piece of legislation over 15 times in this place. Why? Because in mid-2024, Bianca and Boyd Unwin contacted me. They told me about Boyd's daughter and Bianca's sister, Katie Haley, and how she had been brutally beaten to death by her partner. Because he was locked up in prison during COVID, he had received 427 days off his prison sentence due to inconvenience. Now, this took him below his non-parole period, not because he had shown remorse, not because he had been well behaved, but because he was inconvenienced. Now, I'm going to take a step back because it's important in debating this piece of legislation and tell you exactly what happened. I want to know why the government has exempt itself from financial compensation in this piece of legislation while completely ignoring the voices of victims and victims' families. It was in 2018 when Katie was at home with her partner, and he got, according to court documents, angry and lost it. He beat her to death because he did not want her to leave him. Now, we know that stage where people have been in a situation of domestic violence and they make the decision to leave, that is the most dangerous time in that person's life. Her partner didn't like what he was hearing, so he bashed her to death with a dumbbell bar while their beautiful daughter, just 11 months old, slept in the room next door. Now, I know this little girl well because I've spent a lot of time with this family. I've wanted to understand the impact of this piece of legislation. She is the most beautiful little girl. She has been raised in the most loving family by Katie Haley's parents and her extended family. But the fact is, this little girl had the toughest start to life. She lay innocently in the next room as her mother was murdered. Katie received at least 3 blows to the face and at least 2 blows to the throat. And Katie's cause of death was a blunt force to the head. Justice Champion described the crime scene as gruesome and horrific. He went on and said to Shane Robertson, who murdered Katie, "It was clear to me that you attacked your partner in uncontrollable rage and it was your intention to kill her." He showed no remorse. There isn't a good chance of rehabilitation. yet he received 427 days off his prison sentence because of these discounts. The day that he was sentenced outside the court, by the way, he was sentenced to 24 years and 19 non-parole. And I'm going to talk about parole as part of this legislation because it's an important part of this legislation. I believe that in the community, people would imagine that non-parole means non-parole. But no, parole is actually elastic. There's room for it to move, and I'm going to go through that in a minute. However, the day he was sentenced, Miss Haley's dad, Boyd, said this. He said the jail term was in many ways irrelevant to the family as they suffered the ongoing loss. He said, and I quote, "We've all got a life sentence. My wife and I, we don't get to see Katie again. My daughter, my son, they don't get to see their sister again. And more importantly, 2 young children never get to spend any more time with their mum," end quote. I first raised this in this place on the 28th of August 2024, and I've not been a lone voice on this issue. In fact, 3,750 Victorians petitioned the government online to change this. If you look this up, it will say on the website, petition sponsor Renee Heath, response status. This is the 16th of October 2024, by the way, awaiting response. And response due the 15th of November 2024. So I think it's safe to say it's a little bit late. I'm going to read what we petitioned in regards to this legislation. The petitioners of certain citizens of the State of Victoria draws the attention of the Legislative Council that all Victorian prisoners are eligible for emergency management days while incarcerated, which can see up to 4 days off their sentence removed for each day they are inconvenienced due to industrial actions, emergencies, disruptions, deprivations, including changes due to COVID lockdown. This is exactly the settings we are talking about here today. It goes on to say, over the 2 years that Melbourne and Victoria suffered through the world's longest lockdowns, thousands of prisoners received more than 360,000 days off their collective sentences. This is equivalent to over 1,000 years. Well, we were wrong in saying that. More recent FOIs showed that it was in fact well over 800,000 days were taken off, more than 2,000 years worth of sentence reductions. It therefore calls on the government to, as a matter of urgency, to remove eligibility for violent and high-risk prisoners, like the one that took this department to court, a murderer and a drug trafficker, to not be eligible for emergency management days, and to ensure that any reductions do not take them beyond their minimum non-parole period. So that was still, we're awaiting a response. Tabled on the same day in October 2024, 2,855 Victorians petitioned to the government, and that response was due on the 15th of November. However, 6 months later, in June, I got this response, and I'm going to read some of it to you from the then Minister of Corrections. It said emergency management days may be granted under the Corrections Act of 1986 to people in custody who demonstrate good behaviour during periods of disruption and deprivation such as industrial disputes, emergencies and other unforeseen circumstances. They are not granted where a person has demonstrated poor behaviour. We later found out this is false, but that's not what I'm going to focus on today. Emergency management days are an operational tool for maintaining good behaviour during emergencies, as they provide a strong incentive for compliance during times where there is a significant risk of danger, disruption inside prison facilities. But this is the last part. Pandemic-related rules for the application of EMDs ended in early 2023. EMDs are now being used very rarely in line with their targeted role relating to disruptions and deprivations. It explicitly says that ended in 2023. However, that is not the case, because I later received a FOI when there was the change from Minister Erdogan to Minister Hamer, who it's now changed again, but it demonstrated that this was completely false. And the FOI said that between the 1st of the 7th, 2023 until the end of the year, there were 9,882 days granted because of COVID. And then from the 1st of Jan 2024 to the 30th of the 6th, there were 7,697. I should actually quickly add that up. So that's 9,882 plus 7,697, which would be 97, which means 17,579 days for a reason they said didn't exist. Now that's either a mistake that happened over 17,000 times, or that was actually misleading. Then I got another FOI that showed, now this is completely outside the dates that he said they finished. Between July and December 24, almost 3,000. Between January and June, 1,451. And then until last year, July to December last year, 512. Now, so this really makes me wonder, then, let me just find my place, why on earth we are seeing the same piece of legislation that exempts, while still ignoring the voices of victims, manages to exempt the government from its responsibility. And I think there's some other things that I really would like to point out, and that is in the current legislation, which is what we're amending today. It says that the Secretary may, in accordance with the regulation, reduce the length of a sentence of an imprisonment being served by a person or the length of a non-parole period. It's unbelievable to me that when somebody gets locked up, somebody gets sentenced, this man that this legislation is in response to had murdered somebody, had trafficked drugs, but because his area outside was too small, has managed to take the Department of Justice of Victoria to the Supreme Court, and because of the way our laws were written, has been able to extract out of them huge amounts of financial compensation because the laws in this state are weighted far more in support of the perpetrators than they are of the victims. And I think that's an incredible thing that we've got to look at when we're looking at legislation. So this bill, what it actually does is removes the state's financial liability for past breaches of prisoners' open-air rights, affecting ongoing legal claims seeking compensation. So if this government is able to amend this legislation, but they are not doing it to uphold the rights of victims and their families, what are they doing it for and why? So let's look at this bill in detail. What the purpose of this bill before us today allows prisoners open-air access. It allows prisoners open-air access to be restricted due to operational issues. It sounds familiar, doesn't it? But because that is exactly what happens in these cases that the thousands and thousands of Victorians are fighting for change on. It introduces a list of operational considerations that can be taken into account when limiting this open-air access. It applies to unexpected events as well as ongoing operational changes. So this could be something like an outbreak of an infectious disease once again, or it could be something to do with maintenance. It exempts these provisions from the Charter of Human Rights and Responsibilities. Now, if you really want a good read, you should read the Charter of Human Rights and Responsibilities, because when you go through and the Statement of Compatibility, it explicitly says that this bill is actually not in line with the Charter of Human Rights and Responsibilities. It explains why, though. It says, for instance, here, In determining whether some hardship or constraints fall into this category, it's necessary to consider not merely the theoretical possibility, but also what is practicable, reasonable in the context of a prison environment and consistent with the very purpose of imprisonment itself. In other words, what it is saying is that, yes, you do have a human right to liberty, you do have a human right to freedom of movement, but when you are locked up in prison, because you have breached the laws of the state, you actually have some of those liberties taken away. I understand that. But it is also amazing that with essentially the stroke of a pen, and SARC have done an amazing report on this as well, is that you can actually just bypass every one of those Charter of Human Rights consequences or considerations, and the Charter can so easily be overridden. Something else that's amazing, which I think speaks just to a lot of what I believe this government is about. This article was just from a few hours ago from The Guardian. Victoria's new First Nation voice to Parliament has made its first intervention on government policy under the nation-leading treaty powers to call for the controversial bill that would deny prisoners at least 1 hour of open air to be directly scrapped. Goes on. The government will forge ahead with the debate in the Upper House on Thursday, today. It has prompted an intervention from the Gulong Wall First Peoples representative body established as part of their treaty process. For the first time, the treaty process has exercised its power under the State Treaty Act to call on the government to withdraw the bill. Letter to the Minister for Corrections, Ros Spence, the Attorney-General, Sonia Kilkenny, and the Deputy Premier and Minister for First Peoples, Gabrielle Williams, Gulong Wall co-chairs, said the bill was inconsistent with the intent of the state's treaty. So it's just amazing that this government has ignored the voice of victims. It is upholding the rights of the perpetrators above the voices of victims. It has bypassed some of the Charter of Human Rights, and it has not been compatible with the treaty that they have spruiked so much about, yet they go ahead with it. And the Victorian Greens leader, Alan Sandell, said the Labor government can't go out there and champion the treaty one day and the next day completely ignore the principles of it. The Victorian Senator Lydia Thorpe accused the government of treating the treaty like a photo opportunity. Labor celebrated treaty, took their selfies and filled their socials with how historic it was, but the treaty means nothing if the government's First Peoples, when they exercise their power, is ignored when it gives it to them. It's quite an interesting point of view. I just think there's a lot to talk about in this bill. So, what this bill also does is it preserves compensation claims relating to past restrictions on open-air access. So if there's prisoners that have been in, Barwon prison or that have had this access, withheld from them within the Melbourne Remand Centre, well, then they can go ahead. But it applies to new compensation restrictions and ongoing court proceedings. So from here on in, if they make a complaint, they're not going to get anything. But this is the bit that I just find just not up to scratch with what the community would expect from a government. It removes the Crown's liability for compensation claims relating to past restrictions to open-air access, which is found in Part 5 of the bill. And that is the part that I want to look at now. In Section 5, or Part 5 of the bill, it inserts a new section that removes the Crown's financial liability in respect to past limitations of the Section 47, Part 1, Subpart A, or something like that. This provision prevents people from receiving monetary compensation from the Crown. It only applies to claims relating to events before the law. And then this part I find staggering. It does not affect non-monetary remedies or compensation for future breaches. For example, there will be no change to emergency management days that take violent and high-risk offenders beyond their non-parole period. That is unbelievable to me, regardless of the thousands and thousands of Victorians that have petitioned this government, that have said how harmful it is when they're told that the person that murdered the person that was the most precious to them would not get out of jail a day before 19 years, could walk out within 17 or 18 years. That does not reach the threshold of community expectations. That is unbelievable. So what does matter to this government? It's really hard for me to read this in any other way than the way to get the government to change this piece of legislation that we are changing today is not to be a victim or a survivor, because let's remember, in a lot of these cases, the victims are actually dead. They've been murdered. For instance, Celeste Mano, her murderer, by the time he was even sentenced, got over 50 days off his sentence, straight away knocked off because he was in remand during COVID. Katie Haley's murderer got 427 days off his sentence, not because of good behaviour, but because he was locked up during COVID. I'm actually going to find some other, I think, quite staggering numbers. The largest number of emergency management days approved for a single individual, broken down into 6-month time periods. Within 6 months, one offender got 245 days off his prison sentence. Imagine that. And do you know what? These families generally find out through a generic letter. Basically, a mass email that says the person that murdered your daughter, the person that murdered your sister will get out this much earlier. This is another one that I found interesting through FOI. The largest number of emergency management days approved for one prisoner related to COVID-19, 452 days of one sentence. I thought 427 days that Katie Haley's murderer received must have been the biggest amount, but no, it wasn't. It just keeps getting worse and worse. And I don't know where the dishonesty stops, because we were told here in this place, if you go online, you can download the Hansard, you can download the letter from the Minister for Corrections at the time, and it explicitly says that after mid-2023, none of these days applied to anyone. Yet here we are, we've seen over 17,000 days that have been applied after that date. It is unbelievable. So there isn't really many more ways to read this, but the government will change the legislation when it hits their bottom dollar, when it hits their back pocket, when it's going to be a monetary cost to them, not when it is going to be something that will make the lives of victims and their families better. In amending this legislation, they are giving themselves an out when it comes to financial obligations in relation to loss of time outside of the cell, for example, but they have completely ignored the voices of victims when it comes to giving the perpetrators a get-out-of-jail-early card. Imagine being faced with a choice to protect victims who have lost some of the closest people in their lives, who will live with that loss forever, yet the perpetrator gets to leave early from jail if they have been inconvenienced. And the government does not see this as an issue. Why is that? Because it isn't affecting them. This is a government whose list of priorities seem to go in this order when it comes to crime. First, it's protecting themselves, looking after number one. They are exempting themselves from liability. Number two, they then look after the criminal, and who they allow to get time off their sentences, often letting them out earlier than their non-parole period, which in my opinion smashes to pieces the social contract. For instance, in the case of the man who murdered Katie, the public were told that he would have 19 years non-parole. The family were told that he would have 19 years non-parole. But due to these discounts, he is getting out earlier than that. He doesn't even have to report for parole because once you get out of jail, you know, it's taken him below that because of these discounts. Not because of remorse, not because of good behaviour, but because of inconvenience. The very same breach that the government is exempting themselves from liability from. And then the last priority for this government seems to be the victims. They are the last consideration when they really should be the first. For too long in the state of Victoria, there has been a culture where the rights of perpetrators have been put above the rights of victims. The government, in its laws and in its treatment, has given more weight to the feelings of perpetrators than they have to the reality and the lived experience of victims and those that survive them. And under a Liberal and National government, that is going to change. And that is why it is not just talking points for me. Because once you've sat with one of these families and you've looked them in the eye and they've told you about the experience and what it's been like after they've lost their loved ones, it changes your life forever. Just little things like when I was speaking recently to Katie Haley's brother, he was telling me what it was like when he got that phone call and him and his dad hopped in the car to go to the house because they thought that Katie had been murdered. And when they got there, the whole place was cordoned off and there were lights, there was stress, and it began to sink in what had happened. And he said to me, and he was a bit sort of embarrassed about it, and it reminded me so much of my own little brother. He said, all I kept saying to Dad was, Dad, who's going to cut my hair? Who's going to cut my hair? And he said, of course there was so much more. But in that moment, something so horrible that had happened, the only way he could process it was by going through these tiny little things that he found so special that would forever change his life. That is why we have to get law and order under control in the state of Victoria. That is why if you break bail, you should face jail. You cannot keep flouting the laws. Laws in Victoria should be more than just recommendations and suggestions. They should be enforced. We shouldn't be giving kids this opportunity to just titrate up their crimes until all of a sudden there's a reaction and they end up locked up forever. We have to get this state back on track, and there needs to be an accountability and a responsibility for what our laws are actually doing. And the first people we should think about, I believe, are the victims and the people they leave behind. So we are not opposing this bill. But the reason that I've brought these things up is this exact piece of legislation needs much more change. And it shouldn't be just to give the rights of violent and high-risk offenders that are put in cells that are contained more rights because their patio isn't big enough. It should be to at least give the consideration that if non-parole is given, that is upheld by the law. So I hope that there will be more to come on this piece of legislation, and I hope when it does, it gives a lot more weight to victims than it does to perpetrators.